Good morning. Happy Thursday. There is, on information and belief, power back in my office building today, so I'm going to check it out. See if I can't work from work instead of working from home. Because having small children makes working from home next to impossible. The issue I'm going to talk about today, though, is apparently, according to really cool news, and their AI-generated transcript of one of the countless phone calls that Lane Myers has made from jail. I mean, one would expect he would be spending more time preparing his defense than, I don't know, doing jail interviews. But one of the issues that he raised is that he's going to appeal his guilty plea. And I hate to break this to him, but generally speaking, you've got 30 days in Arizona to appeal a plea of guilty. My clock may be a little fast, but 30 days was about a year ago. So I don't know how that's going to work. There is potential for other circumstances leading to a later filed appeal. I don't believe any of those apply. So what does that mean? Well, generally speaking, our judicial system prefers finality. That's what they're looking for. The trial court's decision is final. Now, trial courts sometimes make mistakes, so you can appeal, but you generally speaking have a limited window, 30, 60 days, somewhere in there, to appeal. And then the Court of Appeals decision is final. And, generally speaking, you have a limited window, depending on your state or whatever, to petition the highest court in your state, usually the Supreme Court of your state, sometimes the Court of Criminal Appeals or the Court of Appeals or whatever your highest court is in your state, to file for a petition for writ of certiorari. But the presumption is, because they want finality, people want finality. They want to know that their case is done, that they've won or they've lost or whatever. Generally speaking, the courts want finality. So you have a limited window. There's also a limited window to bring your case, like a civil case or even a criminal case. There's a statute of limitations for civil causes of action and criminal causes of action, because at a certain point in time there needs to be some finality. You can't live in fear of being sued or brought in on charges for an action you did forever. And the courts want finality. There's a logic behind what the courts are doing. So that's issue number one. Issue number two is, even if you have excellent grounds for appeal, and even if you filed your appeal in a timely manner, you have a very, very, very low chance of success. Earl David Worden had some of the best grounds for appeal that I've seen on a criminal case in a long time. I've seen a lot of shitty grounds appealed in criminal cases, and he still lost. So always assume going into an appeal that you've lost. Countless times I've heard auditors, or if you prefer frauditors, if that's your persuasion, countless times I've heard them say, the trial courts are biased against us, so I'm just going to get through the trial court and then we're going to win on appeal. That is the strategy for losing. 99 times out of 100, that's the strategy for losing, because there's two basic ways that you appeal. You appeal based on it's called substantial evidence, basically saying that there's no evidence that the court could have relied on to come up to the conclusion it came up to. That's a very hard burden. You're not arguing the evidence at that point. You're saying that there is no evidence to support the court's position. So if there was one thing the court could have relied on to come to its decision, even if the weight of the evidence was against that one thing, like if you had 99 people testify, Billy Joe did this, and one person testified Billy Joe didn't do it. Under substantial evidence, if the court came to the conclusion that Billy Joe didn't do it, based on that one person, you lose. So substantial evidence is very hard to get around. The other way you do is abuse of discretion. Judges have a lot of discretion in how they come to conclusions. And abuse of discretions is basically saying that no reasonable judge in this judge's position could have come to the decision the judge came to. Again, a very hard standard to prove. Neither is impossible. Sometimes trial courts get overturned. Sometimes trial courts screw up blatantly, and they get overturned. But most appeals end with the trial court's decision being affirmed. Most appeals end up that way. And most cases aren't appealed. Usually you got to get a lawyer to say, yeah, I think we have good grounds for appeal. And then you go up, and then the appeal gets denied. The trial court's decision gets affirmed. So it's a long road to hoe, just off the rip. But if you don't file in a timely manner, almost certainly you're going to lose. Not saying that it's certain, but right out of the gate, if you don't file in a timely manner your notice of appeal, you're screwed. So his odds of getting his guilty plea overturned on appeal are somewhere as close to zero as you can get. Mathematically speaking, it's basically zero. I can't guarantee anything, but this is a sure bet. Like, if you were in Vegas and you had these kind of odds, you would definitely bet against him winning on appeal. And if you bet $1 winning that he does win on appeal, and he does, you would be a very, very rich person, because the odds makers, oof. So basically we'll round it to zero. It's that close to zero. So good luck. And what he's trying to say was the failure, at least from the transcript that Pants read on Really Cool News, was that they didn't set out the facts for him to plead guilty to. Now, I listened to that particular hearing. It was a great recording, but what I did hear was Lane wanted to take a plea. The judge asked him to state the facts that he would plead guilty to. Lane couldn't do it because Lane's retarded. And so Lane stipulated to the prosecutor, Stiles, reciting the facts. And then the judge, after she recited the facts, the judge said, are you saying that you did these things? And Lane Myers said yes. In open court. There's a record of it because I've heard it. Now, I don't know if there was a court reporter present, but he definitely had the facts laid out to him, and he said, yes, I did those things. I have no idea where he's going to come up with grounds for appeal. And appealing his sentencing is, I believe, also a 30-day issue. I believe he had 30 days to appeal the sentencing, which has passed. Now, the final thing before I let you go today is he keeps saying that I can't talk about the case. Again, I heard Judge Metcalf say out of his own mouth, there's nothing preventing you from talking about your case. Now, Lane Myers is retarded, and Lane Myers thinks that because I can talk about the case, that means I can talk about the victim. And the victim and the case, while related, are not the same thing. Talking about the victim's husband, who he's not allowed to harass, calling him the professional witness or something like that, and calling her the alleged victim, is talking about them. Now, he's doing it under the guise of talking about his case. But talking about his case would be like talking about the procedural issues. Talking about the upcoming hearings, about what his defense is going to be, who his witnesses are going to be, if any, what evidence he's going to present. But talking about the victim, who is most likely not going to testify, at the upcoming hearing, most likely. I can't read Stiles' mind, but my best guess is no. Talking about her husband, who's likely not going to testify, isn't talking about his case. It's talking about the victim and her husband. And also this nonsense about, he put I think he's a football player with the same name as the victim. They're going to look really stupid when I'm talking about this other person with the exact same name, and they put it up on the screen. They're going to be stupid, because, obviously I was talking about this other person. Yeah, well, see, unlike Lane Myers, judges, generally speaking, are not retarded. People can draw context clues. Just like you're winking and nodding at your audience, and your audience gets it, who are morons, the judge will also get it. Probably. I can't imagine Metcalf, after being as solid of a judge as he's been this entire time, I cannot imagine he shits the bed at this hearing. I can't imagine that. It is possible, highly improbable. Judge Metcalf is going to see that stuff in context, like the thumbnail of the video. That's going to be a context clue. Everything else that's talked about in that video is the context clue. And then you say the victim's name and you throw up the picture of someone else who also has the same name. The judge isn't going to be like, he must have suddenly switched topics midstream, and now he's talking about a football player. No. I'm sorry. If your defense is, I really hope that the judge is fucking retarded, then that's not a good defense. It's just not a good defense. I'm sorry. This doesn't mean that I'm anti Lane Myers. This just means that looking at what his purported arguments are going to be and looking at the evidence as I understand it, I don't see a good win for him. There's such a mountain of evidence against him and a shit argument for him. I don't see this happening. Add to that the fact that, unless I'm mistaken, and I could be, but Resnick was assigned as the attorney for the revocation hearing. Not as elbow counsel, but as the attorney. So let me posit to you that Lane Myers isn't going to be making any defenses. It's going to be Resnick. And I hope and believe that Resnick is going to make a more coherent argument against the evidence than Lane Myers could. I'm not saying it's going to win, because again, he's human, and there's a mountain of evidence against Myers, and there's not a lot of evidence for him that I haven't seen any. So, but good luck to you, Lane. Best of luck. I hope you don't eat prison food for the next 4 years. Thanks for watching. Have a great day.